Is that Janice? Can you hear me? Hey, Walter, can you hear me? Hey, Walter, can you hear me? because I cannot hear anything yet. Can you hear me, Walter?
James.
Okay.
I am stepping away for 1 second just to get some water. Morning, everyone. It's 10:59. We are going to try to get started by 11:05. We still have folks signing in, so just give us a few minutes and we'll get things going. Glad to see everyone this morning. You are joining us this morning, we'd ask that you change your screen name to your actual name so that we can see who is on the call this morning and can identify you better if you ask a question later on in the session. So for folks who are using numbers or code as their name, please go into your settings and put your actual name in the settings. We'd appreciate it. Thank you.
Hey,
Hi.
I'm on the Black Parent Workshop thing. It didn't start.
Oh, we had a DJ there for a second. We need some music
No.
in the background.
I was like, James, I didn't know you had a talent for DJing. But
Man of many trades and activities, all of which legal. All right, I've got 11:05 on my end. Walter, why don't we get started? Thank you, everyone, for making time this morning to join our first town hall in a while. I would say that I think the last one was about 3 years ago, if that. And we felt it was time to let everyone know our perspective on the status of what I characterize as a significant settlement with the district. And I use that word specifically because as try as I might, I have not been able to find something similar around the nation. And from what we'll be talking about today, I think what we have done here has resonated across the nation. So before we get into the nuts and bolts of today's meeting, I want to take you through what we propose to discuss in the order we wish to discuss it. So first I will introduce Walter and myself. We will take you through a chronology that led us to the lawsuit, which led to the settlement. We will describe the framework of how we constructed the settlement. We will talk about what we believe we have accomplished. We'll talk about what we believe is still in progress. And then we'll talk about next steps in our view. So with that, my name is James Davis. I'm the chairman of the Black Parents Workshop. I joined the Black Parents Workshop in 2017 after losing a bid to become a board member of the South Orange Maplewood School District. I am proud to say that I think I got one of the lowest vote totals ever in the history of the election, but I learned a lot. And what I learned was, in essence, how the district worked. And I figured that with all that knowledge, a loss was not going to keep me from providing some kind of value for the students in this district. I was going to introduce Walter, but he's kind of got a large background. So I'm going to let him introduce himself and then we'll get started after that.
Good morning, folks, and thank you for joining this call this morning. My name is Walter Fields. I am the founder of the Black Parents Workshop. I am a former parent in the district with a daughter who graduated from Columbia High School in 2016. And I continue to be involved with the Black Parents Workshop on their advisory board and as a non-paid consultant. My background is civil rights and journalism. And it was our intention from the very beginning of the founding of this organization to try to find a way to cooperate with the school district so that we could make some significant systemic changes that would advance the interests of Black children in the community. Seeing that that was not possible after several years, we made the hard choice of pursuing litigation, and that's where we are today. Now, I also have to state that we are not in litigation with the South Orange Maplewood School District. That is over. We have a settlement agreement that is public record. And so this settlement agreement should be discussed publicly by this Board of Education. There's nothing prohibiting them from discussing the terms of the settlement or the progress in complying with the settlement with the public. And I want to clear that up because I've heard too many instances where responses from the board has been, oh, we can't discuss that because we're in litigation with the Black Parents Workshop. That is patently false. We are not in litigation with the school district. We have an agreement that both parties have signed. This agreement is public information. You should have access to it. And the board should be discussing this with the community because that is their obligation as a board, as well as one of their obligations under our settlement agreement. So I just wanted to make that clear.
One of our team could not make it today, attorney Robert Tarver. And I will ask everyone to put their mute buttons on when asking a question to keep the audio clear. We are recording this meeting. Robert Tarver, our attorney, could not make it, and I will cover his portion of this meeting. And if you have any questions for Rob, we can take that question to him and he'll get back to you. So with that, Walter, why don't you take us through a little bit of the history here in terms of how we even got to the lawsuit in the first place, the rationale for the lawsuit, and then we'll start to get into some of the nuts and bolts of the settlement once people get some context of why we're actually here today.
Sure. And let me begin by saying that this lawsuit actually has its roots as far back as 2007. So in 2007, the administration of President George W. Bush issued a memorandum to all school districts across the country, advising them that if they have statistics that reveal that Black students are being denied access to advanced level and advanced placement courses, that they are likely in violation of the Civil Rights Act of 1964. When the Obama administration came in 2008, they looked at what the Bush administration had done. And in 2009, they issued another memorandum and warned school districts again that if we find that Black students are being denied access to advanced level courses and advanced placement courses, you will likely be in violation of the Civil Rights Act of 1964, and we will take action. When the US Department of Education began looking at the data, the American Civil Liberties Union was also looking at the data. And the American Civil Liberties Union was alarmed at the disparities that they saw in the South Orange Maplewood School District, and actually communicated with the US Department of Education and said, you should look at this data. At the time, there was a reluctance to do so because by perception, the South Orange Maplewood School District was considered to be a very progressive school district. However, when DOE started digging into the data, they were alarmed, and they realized that our district had one of the most egregious examples in the United States of practices that were discriminating against Black students. It was at that time that they sent a warning to the South Orange Maplewood School District and said, you need to fix this. And the South Orange Maplewood School District entered into an agreement with the US Department of Education Office of Civil Rights. Simultaneously, my wife and I pursued a civil rights complaint on behalf of our daughter, who was denied access to an advanced mathematics course that she had qualified to enroll in. She had scored advanced proficient on every statewide mathematics class. She had an A in mathematics in 8th grade, and the district was about to place her into a lower, much lower level math course for 9th grade. What we found out the morning of our meeting with the district to settle our case was that the US Department of Education was trying to settle their case with the district. So we had two actions going on at the same time. After those incidents, I met with a couple of Black parents, and we understood that what we had was a systemic problem with this district, and we created the Black Parents Workshop. Fast forward. So after several years of really struggling to work with the school district in trying to rectify these issues, we had multiple discussions with multiple school district superintendents about this issue. We determined that the only way we were going to ever resolve this was through litigation. It was an action that we reluctantly filed because we understood not only the cost of litigation, but the distraction of litigation from actually solving problems at times. But we did so. So we filed the lawsuit. The district responded. We ended up having depositions. I was deposed over 2 days for 7 hours. The superintendent of the district was deposed. And after those depositions, the district said to us, let's settle this matter, which we willfully did. And really were enthusiastic about what we thought was going to be a new era of cooperation.
Let me add one
That-
thing, Walter, that it
Yes.
didn't discuss, which was the Black Parents Workshop did present a settlement offer in April of 2019 that largely tracked the final settlement. Yet between April and roughly March of the next year, there was no response to that settlement offer.
And thank you for that, James, because what we put on the table is identical to what we eventually settled with the district. And it was never about money. It was all about children in this school district. And I want to emphasize that because there had been too many times where we heard rumors where people were saying, well, the Black Parents Workshop is making money off this lawsuit, or James Davis and Walter Fields is making money off this lawsuit. First of all, that would not be allowed in federal court. And number two, that was never our intention. Everything we asked for in this settlement was for Black children in our school district. So here we are today, struggling, quite honestly, to get the district to honor the settlement that they agreed to. We didn't twist any arms. We didn't make any bogus threats. We came to them in all sincerity and said, let's work together, because at the end of the day, this is about helping our children in a community that claims that it cares about all children. And so that's where we are. And I will turn it over to James to go into the details. And James, as you go through the settlement, I am going to actually share the settlement document on the screen so folks can see.
And I will add and supplement what Walter just said, which is we made multiple and numerous attempts to help and assist and move forward what the district had already agreed to with the government with respect to addressing the inequities that they had previously acknowledged and signed on to with the government. And the frustration came when we didn't seem to believe that the district collectively had bought in to the endeavor of solving these problems. And that's what prompted the strategy that we undertook with respect to the lawsuit. So I want to make it clear that this organization is not just about filing lawsuits, but for getting things done and changing outcomes.
And James, we were not the only organization. So we also had the ACLU and the UCLA Civil Rights Project, two well-established civil rights organizations who understood the problems in this district and sought to make certain that the deficiencies that were identified, not through hearsay or rhetoric, but in hard data, would be addressed. And so, you know, part of the reason why we're doing this program this morning is to clear up any misunderstandings or confusion about how we got to where we are today.
So with respect to the settlement and the construction and format of it, although those kind of technical aspects were handled by the lawyers, and our lawyer's not here, I will try to give at least a semblance of what these documents are supposed to do. First and foremost, they're supposed to acknowledge and expressly show and demonstrate a meeting of the minds between both parties. Obviously, the BPW was the plaintiff in this suit and the district was a defendant, but this is in essence a contract. And when you have a contract, both parties agree to the terms within the contract before they actually sign it. And there are aspects of the contract that, even though previously we were in the eyes of the court adversaries, to get to the conclusions and the outcomes that are desired within the construction of the settlement, the parties have to work together. And I want to stress that because what you're going to hear today is that part of the agreement has been one of the biggest challenges in our view. So although Walter is showing the settlement, it's going to be hard for you to actually read it while you're sitting there. So we'll try to post a link so that you can read it at your leisure. You can always ask a question after this meeting regarding an aspect of the settlement if some part is unclear to you, and we'll address it that way. We just wanted to make sure that we at least had it on the screen so that it had some context to this conversation. So what I'm going to do now is give you kind of a high level rendition of the various sections applicable to the students in the district and the overall activity that is, in our view, supposed to be occurring to help them and to address the inequities that we had discussed in our complaint. So there are 31 sections to the settlement, but I'll say at least half of those sections are what I'll call standard court lawyerese type provisions that any contract would have as two parties demonstrate their meeting of the minds. So I'm only going to go over what I'll call the nuts and bolts of the provisions that will impact the students. So first and foremost, we have Section 3. Section 3 was created to pretty much lay out a game plan for the district with respect to preparing Black students for taking AP classes when they got to high school. And this plan was to actually start in kindergarten.
Oh,
The way we intended to effectuate that plan was to have Dr. Edward Fergus, who was an associate professor at Temple University, to collect data over the course of several months and then compile that data into a comprehensive equity plan.
did that happen?
Can you put yourself on mute and then we can answer questions at the end, please? I think that's Valerie, sorry.
Sorry.
And so in the course of Dr. Fergus's efforts, we had a couple of meetings with him personally. We had some meetings with him and the district personnel. And well, let me say this. The settlement was signed in July of 2020. And I need to add this context because I think it's important. And forgive me for not saying it earlier. As you all know, that was right in the heart of COVID. And so the school year of 2020 and 2021 was all remote. The Black Parents Workshop did not, and purposely did not, attempt to, in essence, put forth any demands around our settlement during that time. And the reason we didn't do that was because we knew that everyone was going through the trials and tribulations of remote learning and COVID. And we didn't want our settlement to be a distraction to that. All that being said, there were certain aspects of the settlement that already existed that could have been addressed during that time without much effort, in our view. And so when we kind of came out of COVID, I'll say that we re-engaged with the district roughly in June of 2021 on a purposeful level to see where we were. And we were kind of shocked at how behind the district was in doing anything with respect to the settlement. And so, and we knew, well, and we knew that the effort to get information for Dr. Fergus was not easy. And so the first date that we were supposed to see a draft of his report was roughly November of 2020. And this again is Dr. Fergus working with the district directly. We're just asking for updates as necessary.
Oh,
Hey, Juan, can you put yourself on mute, please? And sorry, I lost my train of thought. We did not receive the update. I'm sorry, Dewan, if you're on the line, can you put yourself on mute, please?
Walter can mute him directly.
Yeah, Walter, can you mute Dewan?
Yeah.
Yes.
Now you have to unmute James yourself.
Sorry, I use Zoom, but never actually as an administrator. So in any event, in November of 2020, we were supposed to get our first update of the Dr. Fergus report, but we were told that it would be delayed. And we were understanding of that because it was COVID and remote learning and things were not normal. The dates kept getting pushed. And then we finally received Dr. Fergus's report in June of 2021. Of course, not everything is perfect, but we understood the reasons why the report was late. However, when we read the report, we were a bit concerned because, as I stated and as the settlement states, Dr. Fergus's report is supposed to include K through 12 data. The report we received only included data for the grades 6 through 8. Now, I don't want to go into the details of why that data was not included, but I will say we have asked for that data to be included. We have not received a response as to why the data has not been included or when it will be included. And we also found out that the month we received the report from Dr. Fergus, and the settlement also gives Black Parents Workshop the opportunity to comment and to provide input on the report. We did not know until after June of 2021 that Dr. Fergus's contract actually ended in June of 2021. So I'll just say that again, we don't know what the status is, but we know that the information is missing and it needs to be included with Dr. Fergus's report for it to have any value with respect to this settlement. Section 4 of the settlement involves the integration plan. Now, as many of you may know, the integration plan is actually already in effect. What many of you don't know is that this settlement requires the district to give an opportunity for the Black Parents Workshop to provide input and commentary on the plan and to present us with the plan. That has not happened. And so again, we have expressed these concerns with the district. We have yet to receive a response that demonstrates our concerns from the district on that point. Section 5 is something that the lawyers constructed, which was actually a good thing. In order to determine whether or not the district has met its obligations with respect to Section 3, the Comprehensive Equity Plan, and Section 4, the Integration Plan, the district has agreed. I want to stress that the district has agreed, along with the Black Parents Workshop, to let an outside monitor determine whether or not the district is in compliance with the four corners of the settlement agreement. That person, selected by both parties, is former New Jersey Supreme Court Justice John E. Wallace. The district was required to reach out to Mr. Wallace to then update him on the parameters and specifics of the equity plan and the integration plan so that he would have a basis for then determining whether or not the district was actually complying with it. So it wouldn't be Black Parents Workshop making that determination. It would be an independent party, John E. Wallace. It is my understanding, and I'm not within the district, but from all intents and purposes, it appears that Mr. Wallace has never been contacted by the school district. And I'm only saying that as my perspective. Yes, Walter.
If I could add, because I think folks need to understand what Justice Wallace would be monitoring.
Please.
So he would be monitoring Section 3 and 4 of this settlement. And some of the items under Section 3 include how Black elementary and middle school students will be assisted in preparing for advanced level study at Columbia High School, how current Black Columbia High School students enrolled in advanced level courses will be supported through tutoring and enrichment and programs that will address issues of proficiency, student trauma, and effective study habits, how current Black Columbia High School students not enrolled in advanced level courses will be supported and encouraged to enroll in these courses, and what programs and services will be offered this student population. This is important because there is current board policy that speaks to the issue of enrollment in courses and the rights of students to enroll in courses, as well as the fact that the district policy requires that the proportion of Black students enrolled in these courses should be proportional to the student populations in the schools. And so Justice Wallace would have clear benchmarks by which to monitor this district and this settlement. I just wanted to add that, James. I'm sorry.
No, please, please. I'm glad you did. So that is Justice Wallace's role. Again, if the district has reached out to Justice Wallace, it will be news to me because I have not heard or have seen any evidence of that contact. Plus, I don't know how he would even be able to do his job at this point with the Fergus plan that we have expressly demonstrated verbally and in writing that the document is not complete and not accepted by Black Parents Workshop at this time. So the question remains, when will Dr. Fergus finish his report? When will it include the K through 12 data as written? And when will the district then implement that plan after BPW has a chance to review and comment and both parties agree on an implementation plan going forward? Section 7 involves the Amistad curriculum. We felt it important that if you were going to focus on your curriculum on the teaching of Black history and related topics, that it should have a source of information that is reliable and accepted widely. And the New Jersey Amistad curriculum, in our view, fits that bill. So by the virtue of the settlement, the district was supposed to get validation that its curriculum coincides with the state Amistad curriculum standards to make sure that we were starting from a point of agreed upon understanding about how Black history and related topics would be taught. We have received a letter from the attorney for the district that states that the district has received that validation, and we are very happy about that. Coincidentally, about 2 weeks after we received information on that validation, we also received some disturbing news about a course at Columbia High School whereby a teacher took it upon herself to demonstrate how slaves were punished during slavery times, and we're using kids in the classroom to demonstrate that. It harkened back to the slave auction poster controversy and the actual live slave auction that occurred at an elementary school several years ago. So we, upon hearing this information, reached out to the district and to find out if it was true. And we actually received an email from their attorney stating, yes, what we heard was actually true. So that raises the question for us. If you have received information that your Amistad curriculum has been validated by the state, how are you in fact as a district communicating that to your teachers? For example, is it a requirement that your teachers through their personal development courses get trained in the Amistad curriculum, or is it optional? If it's optional, is there encouragement to actually take it so that you can actually, as a teacher, coincide with the district's overall agreement with the Black Parents Workshop settlement to make sure these courses are taught in accordance with our agreement? So that question remains, despite the fact that the district did get its validation of whether or not it will actually do something with its teachers to ensure that they collectively understand how and in what way these courses should be taught with a sensitivity and care that it demands. Section 8, course enrollment data. Every January, the district is required to let the public know the race and gender demographics of various courses regarding AP courses and others, so that the public can see the numbers of whether or not the disparities that caused the lawsuit and settlement in the first place are being corrected. The district has had these 2 meetings, excuse me, one in January of last year, and they also actually accelerated the meeting to December of 2021 instead of January of 2022. So they are fulfilling this part of the agreement, but this part of the agreement was to coincide and show the metrics of whether or not the comprehensive equity plan by Dr. Fergus was actually working. So if the two pieces aren't there, then having this course enrollment data presentation is not really, in our view, a substantive event, because you're not doing anything on the front end to try to change the numbers that we know are already disparate with predominantly number of white kids in AP classes versus Black kids. So anything you want to add to that, Walter?
No, I think that's fine, and they have reported out. And I think part of what we tried to achieve through the settlement is to increase transparency in the district. Like, this data should not be hidden. It should be well known so that the public can actually see the progress or lack of progress that the district is making. And this was a big part of the settlement agreement, the issue of transparency.
So section 9 is regarding suspension data. So back in 2014, when the ACLU came in and gave their report that led to the resolution agreement with the Office of Civil Rights and the district, there was data that, for example, if you had 90% of suspensions for Black children and roughly 10% suspensions for white children. And there was concern, obviously, that, why was that happening? And so what we were trying to do with respect to the settlement was to make that information more transparent. And in the course of this provision, the district is required to display the monthly suspension data at the schools around the district. And they have been doing so. There is some question around the accuracy of the information. So for example, as many of you may know, there was a board resolution back in October to have a suspension moratorium. And although the goal may have been to curtail what was already being disparate suspensions, it also showed us something else. The meeting that the board passed the suspension moratorium, there was discussion around 3 suspensions in the month of September, and those suspensions, I believe, were all Black children. Following the information closely, I noticed that there were actually 5 suspensions of Black children in September, but it wasn't updated until January of this year, which led me to believe that the system of providing information within the district 4 walls is not being accurately disseminated and distributed and uploaded into the system. And so although the district is meeting its obligation by making the information public, I now question the accuracy of the information. And I request personally that the district let us know how the information is compiled, who is sorting it, so that there is some accountability for this, because we can't know as the BPW, we can't know as a public what is actually happening with respect to suspensions unless there is some assurance that the data is actually being presented in an accurate manner. Section 10 required the district to hire an assistant superintendent of access and equity, which it did. Dr. Gretel Perez was the assistant director of access and equity hired by the district to, in essence, oversee the areas of access and equity, which would include some of the requirements of this settlement. I am sorry to say that Dr. Perez resigned late last year, after being on the job for about a year and some change. Um, and no replacement has been made yet. I found the first hire, Dr. Perez, to be very candid in her desire to implement the requirements of the settlement. But there was also some frustration. And so I don't know exactly why she resigned, but I'm going to surmise that some of it may be due to the frustration of trying to put forth policies or plans or proposals to get some of these things done, not just in our settlement, but in other areas. So we'll be waiting to see whom the district hires next. And hopefully that person will have enough authority and power and experience to make some significant changes in the areas of equity in our district. Section 11 is regarding the hiring of Black teachers in the district. I unfortunately don't have those numbers in front of me. I do know there have been a lot of teachers leaving based upon some union contract negotiation issues over the last several months. But we've been working with the HR director, Ms. Stacy Robinson, directly. We've had a couple meetings with her on this topic. She's been very helpful with her ideas. She's definitely doing the footwork in trying to get the district to in front of different schools and colleges. Walter has helped her tap into his pipeline of HBCUs. The challenges, however, are beyond kind of the three of us talking. Some of those challenges are, the cost of living here in South Orange, Maplewood. How do we account for a new teacher trying to move here and live in the area where he or she is going to work? The current issues regarding the union. People see this stuff in our various news outlets here. How is that going to influence a person's decision? So there are a lot of factors flying around, but we are still going to work with Ms. Robinson to try to get as many people here as possible, or as many people interested in these roles and positions here, because we definitely think it's needed. And with that, I will turn it over to Walter to add any other thoughts.
And James, I also want to make clear that the district has raised the issue of its budget in terms of hiring. And so we have asked the district to reach out to the local Achieve Foundation to see if they will partner with the district to make sure that we can put in place a program to attract Black teachers. When we first started talking to the district about this issue prior to the litigation, we went to my alma mater, Morgan State University, and met with the School of Education and Urban Studies. And at that time, we were told in that meeting was a teacher, TJ Whitaker, as well as the former assistant superintendent of the district, and his name escapes me now. But we met at Morgan State, and we were told that the district would have to do some things in terms of cost of living adjustments, providing additional resources for teachers to move in to the community, making sure that the district was prepared to support Black teachers and retain Black teachers upon hiring. And Morgan State agreed to work with the district. But we understood that resources were an issue. So we've asked the district to communicate with the Achieve Foundation, and the foundation's goal is to advance issues of academic achievement in the South Orange Maplewood community. And I'm hopeful that the Achieve Foundation will step up because this is a real issue. And it's not just an issue in South Orange Maplewood, it's an issue in many suburban school districts across the country. And it's become even more so as we're seeing large numbers of teachers leave the profession. So I just wanted to give a real understanding that we are trying to work with the district on this matter, as we worked with the district on the issue of the Amistad curriculum. The Black Parents Workshop has never declined an opportunity to work with the school district. What we are frustrated by is the seeming non-interest by the district's leadership in resolving these outstanding issues. And we want to make it clear to the community that, and here's another example, we have not had a formal meeting with the Board of Education on the issue of this settlement, despite us satisfying our part of the agreement and signing this agreement. We've never had a meeting about the settlement agreement. And so here we are, and we're looking at the calendar, and quite frankly, the school district is running out of time.
Yeah, I will add to that. One of the reasons we're having this town hall is to, one, let people know what's going on, who have seen different posts from us, who have seen different stories in the Village Green, but have never had a chance to actually sit with us, maybe ask a question or two. And so we wanted to provide this opportunity for you to do that. And I purposely invited the school board, Dr. Taylor, because we are focused on making sure that this process is as transparent as possible. We are not trying to hide anything around getting these matters taken care of, because they're important. Whoever you talk to always says, oh yeah, there's inequity in South Orange Maple. It's gone on for a long time. It's time for it to end. We want it to end too. But we don't want is to make the same mistakes people have made in the past by not addressing them wholeheartedly and expressly and transparently and involving the public. The people on this call today and the people who will be reviewing this recording are just as important as our organization, because you have a voice in this too. And so we want to make sure that you are empowering yourself, because this document also impacts your children, not just mine. Walters has graduated, but not just his. It impacts all of us. And we want to make sure you parents are empowered as well. So I asked people if they had any questions, they can put them in the chat. Let's see.
Or you can also raise your hand if you know how to use your.
And then once we're done with that, we'll kind of give the next phase that we believe is going to happen for BPW and this settlement.
Okay, see a hand up, Michael Paris.
Hi, thank you so much. I want to thank Walter Fields and James Davis for their leadership and efforts on this over many years. It is a benefit to all of us that this is being pressed. So really, from the bottom of my heart, thank you both for doing this. I have 1,000 questions. I'm going to ask two. One theoretical question is, it seems the ideal world is proportional representation by demographic groups in levels. Another approach, another concern would be, gee, wouldn't it be nice if we had many fewer levels and more equality, and maybe a different theory of education that goes with fewer levels? Certainly we have to have some tracking. Not everybody can do AP physics. But, ninth grade social studies should be entirely de-leveled. We actually won that for 1 year, but the teachers covertly eliminated it. So this is an example of that's an issue, I think, that reasonable people can disagree about, but should be discussed. And the other question I have for both of you or anyone else is the theory of change. How does change take place? I could imagine a superintendent saying, you all are not the policymakers. You sued us, we settled. You can't tell us what our policies are, and you can't tell us how to allocate our time and attention. And that seems to be, I noticed there's 4 board members here. The principal of high school is here. The superintendent of schools is not here. That's telling. What would be the process? Social protest could be one way. Maybe that would be counterproductive in this community. Maybe more work with students and teachers. I know you've done a lot. Maybe, a bigger tent of people who really want to see this pursuit. And that's two questions. So one question is leveling, proportional rep versus less leveling. Second question is how do we produce change? Third question, I'm sorry, it's not a question. Can we all have access to whatever Fergus has done? I mean, this is probably, it sounds like he hasn't done, the sections 3 and 4 say there's a plan to plan. Okay, what's the plan? What's the document say? And is it enough to move forward or not? Thank you so much. I'm sorry to have taken so much time with that.
On your first issue, leveling. So our position has always been, and it's in board policy, about proportionality in terms of representation in classes. That's current board policy. We believe the district should be striving to increase the quality of all course offerings. We never said we expected every Black student to be enrolled in advanced placement courses. What we have said is that the district should not prohibit those students who want to enroll. And if you are enrolled, the district should find ways to support those students. An inordinate amount of money is spent by parents in the South Orange Maplewood School District on tutoring. So if that is the case, we know that not just Black students, but all students have difficulty at times in these classes. When my daughter was in advanced placement courses, she was always one of a handful of Black students in a course. So that's our perspective on the leveling. In terms of the theory of change, in an ideal world, we should not have to litigate. In an ideal world, we should have a community that demands that its local school district, number one, abide by the law, and number two, provides opportunities unencumbered to all of its students. That has not been the case in the South Orange Maplewood School District. And it was not the case before we litigated, and it's not the case now. And so I think in terms of our role, what we attempted to do early on was to appeal to the good conscience of our school district leaders. And when we found that there was no interest in moving forward voluntarily, we used litigation as a leverage point. Where we are today, though, needs to be a community demand for better. Like, the community needs to step up. It shouldn't just be the Black Parents Workshop. It should be every group in South Orange Maplewood, every taxpayer in South Orange Maplewood. Quite frankly, both town governments should be pressuring the school district to do better, because we all know at the end of the day, everyone's concerned about property values. Well, what really establishes property values in the state of New Jersey is the quality of your local school district. And so what we find is that we don't have enough people in the community working on this very issue. And we tend to be at odds instead of saying the data is clear. And you're right, Michael, that Fergus plan should have been made public. Like, we have a real problem in this school district of not providing information to parents and taxpayers. All of this information should be public. There should be a public discussion at a school board meeting about this settlement so that the public can weigh in, because ultimately, the only people that can hold the school district accountable besides a federal judge are the people who live in these two communities.
People actually Oprah the settlement, Michael, to see how much money Walter and I received versus what the district is required to do. And so, some people just have a certain focus on what we're doing versus what could be helping the kids. And again, that's why we're here today, not just to even to describe the settlement to folks, but to also kind of give a call to action for people, to demand that there be a discussion on these topics. Frankly, I would prefer there be more people involved in that, be more time for me to do other things. But the fact of the matter is, we have to start pushing this thing forward so that we're just not talking about it all the time. And I'm frankly sick of talking about it, having discussions about it. I would like to see some more action on the part of our leadership, working with the teachers, because you can't do one without the other. But the acrimony that we currently have with this union issue is going to impede progress for the kids, unfortunately. But that's just something we have to work through. But we're trying to lay the foundation at this point. And so we're going to keep pushing forward, hopefully with the help of others, especially on this call today and others that will review this recording.
And the truth of the matter is, and you know, for those of you who have law degrees or are lawyers on this call, you know that litigation is a torturous process. It's never fast, and it can be very exhausting. And so through the discovery process, we must have had 40,000 documents laid upon us by the school district. And when we wade through all these documents, you know, it really became clear all of the missteps that the district had taken in terms of trying to do the very things that they claim that they wanted to do. There was absolutely no pushback from the district's council when we were in negotiations finally around this settlement. During my 7 hours being deposed, it was not an adversarial deposition. We were all in the room in an agreement that the district had to do better. And so the frustration is that as we get to the point where the rubber meets the road, when is the district going to step up and do what it agreed to do? Like, we're not asking the district to do anything that it didn't say it was willing to do as part of this agreement. And I think it's a real failure of leadership at the district level between the board president and this district superintendent. For the brief period that Tom Ficara was the superintendent of this district, I will tell you, that was the only time that I felt that there was honest, open, and transparent discussions between the district and the Black Parents Workshop, and that we had a superintendent who made clear that he wanted to fix what was wrong with the South Orange Maplewood School District. I don't feel as though we have that same understanding or commitment today.
Let me give you an example with that. I mentioned before during the call earlier that in April of 2019, Black Parents Workshop presented the settlement agreement to the district, which was unheeded. We did hear from the school district when they found out that Walter had resigned his position as chairman and moved to Baltimore. That's when they decided to depose him. In my view, being an attorney myself, I think they believed that he would not come back for a deposition being in Baltimore, and that they could file a motion to dismiss the case based upon his lack of attending. Walter drove up and again spent 7 hours being deposed, much to their chagrin. And that is what I believe kind of turned the tide on this, because they realized they couldn't wait us out. So remember, we filed this thing in February 2018. So they were obviously waiting us out in the hopes we would go away. And to give the new board members credit, the ones who were on this call today, most of them weren't on the board that actually approved this settlement under what I'll call dubious circumstances. I don't think they want to actually move this thing forward. So the new board members have a chance, now that the old ones are gone, to actually right that wrong, if they so choose to do it.
I think there's a question in the chat you might want to address from Sandra.
Let me take a look here.
I can read it for you.
Yeah, why don't you read it, please?
The NJQSAC review holds the district accountable to respond about Amistad implementation and training. What is their response?
Well, given the fact that they just had the curriculum certified by the county superintendent, we have to wait for that review. And so what we are hoping, and James spoke to this, that it's one thing to adopt the curriculum. It's another thing about the implementation of the curriculum. This recent incident that occurred in Columbia High School causes grave concerns that our teachers are not prepared to teach this curriculum that the district has now adopted. And the State Amistad Commission has annual summer trainings for teachers around this curriculum. So we will now move to discussions with the district about how are you helping teachers through professional development be prepared to teach the curriculum.
And I'll follow that with the same principle applies to the suspension issue we talked about before. There was a suspension moratorium voted on and approved in October. At the time, there were reported to be 3 suspensions in September. Now there's 5. But now there's actually a total of 14 Black children suspended after the moratorium. So what is actually happening within that time frame that causes the suspension or non-suspension? How is the district avoiding suspensions based upon the moratorium? What restorative action plans are they implementing to help kids avoid being suspended? What infractions are causing suspensions? All these things are unknowns because in my view, no one's actually collecting any of that data. So how can we know if a moratorium is actually working if there's no data publicly displayed, publicly discussed, so that we know it's working? So in my view, there's a moratorium that is performative in nature only. It makes people feel good, but it's not actually helping our kids. So we need to get past the fringes and do deep dives into these things. And again, we've never shied away from helping. But ask me how many calls I get from the district to help on this stuff these days.
And I will also add.
Oh, before you do that,
We
well,
also
the
need-
person speaking before was Narda Green, one of the BPW trustees. Thank you, Narda, for helping.
You know, I'll also add, and I put it in the chat. So while we as an organization have litigated on behalf of Black children, you really need to go to the Instagram site, Blacks at SOMSND, because you will read there the stories of Black children and what they've experienced in the South Orange Maplewood School District. I get pretty frustrated when I hear the denials about what happens in our school district. And so this Instagram page really gives you some insight into how Black children feel about their treatment and the lack of opportunity they've experienced in this school district. I would think that a community that is as educated and, you know, supposedly progressive as South Orange Maplewood School District should be able to tackle these issues. And so I think it's a lack of will, more so of the people who we've elected to represent us in the school district, than it is by the community itself. And so we need to keep in mind that what really matters here are the children. And is this going to be the type of community that continues to deny, despite a mountain of evidence, that Black children are not treated fairly and given the same opportunities as white children? That's the bottom line. And here's a great opportunity to show yourselves as a leader on this issue across the country. We're witnessing across the country the emasculation of public education, book bannings, you know, efforts to prevent the teaching of Black history. And so here we are in South Orange Maplewood School District, a very small school district, that we can set an example for the world of what's possible if people act in goodwill. And I'm hoping that the community will begin to be more vocal on these issues, because the community itself will benefit if this situation is ever resolved.
So since our settlement and some of the news stories following that event, BPW has been contacted by various groups and or individuals across the nation, actually. And there are even some that we are working with now to help them figure out what's the best course of action in their communities. Because people are seeing the settlement as a guidepost for them and a possible way to get movement in their own districts. Most recently, there was a group in California that we've been working with quite closely. And so if this district wants to be a model, there is the opportunity to do that because people are watching what's happening here from outside. And I think we have all the ingredients. We just have to have the will.
And I will say that, in terms of specifically this settlement agreement, we have set a deadline of July 1st to see where the district is going with all of this. And if we don't see progress, we are prepared to go to a federal judge and seek a federal court order on all of the unresolved issues around this settlement. This settlement agreement does give us the right to go back to court, and we will exercise that right if we don't see any progress by July 1st of this year. Because at some point in time, it's put up or shut up on the part of the South Orange Maplewood School District. And that's where we are right now. And people are watching. James mentioned California. We are helping 7 communities in California that are forming the California Statewide Black Parents Coalition. We are helping parents in Colorado. I currently serve as co-chair of Strong Schools in Maryland, which is a statewide education equity organization in Maryland that has advanced probably one of the most exhaustive education reform packages in the country's history, the blueprint for Maryland's future, a 10-year, multi-billion-dollar package to create a more equitable public school district. So there are things happening. And on April 28th, we are going to be participating as part of a nationwide Black and Brown Parents Call, and we will make that Zoom invitation available to everyone towards mid-March. But what we are trying to do is sound the alarm that if we don't fix what we can, we will all suffer. Because when you look at the issue of the economic security of your community, of communities across the country, it is going to be contingent upon the education of the fastest growing segment of children in America, and that's Black and Brown children. And so we can either ignore that reality or make sure that we're providing all children a quality education so that this nation will benefit. But we are prepared to use every device necessary legally to make certain that this district honors its commitment. And I would ask all of you on this call, if you're truly concerned about this, reach out to your Board of Education president, reach out to your school district superintendent, and demand at an upcoming Board of Education meeting that on the agenda, there is a discussion about this settlement agreement, point by point, and have the district report back what it claims it has done in terms of complying to this agreement, because that's the way we can hold the school district accountable.
Let me piggyback on what you said around the settlement becoming an order, because it's very important. I know we don't have a lot of attorneys on the phone, so I want to make sure that they understand what actually that means. So as I described before, a settlement is a meeting of the minds between two parties that agree, and they write down their agreement, and then they'll both work together to actually make the agreement happen. Based on what Walter just said, if Black Parents Workshop can demonstrate to a judge that there are certain provisions that the district has not complied with, we can petition that judge to make the agreement a court order, which then becomes a whole different realm of requirements for the district. The district is in the best position it can be right now working with us. Once a court decides to make it an order, it's even out of our hands at that point, because the court can decide how it wants things to get done. But we can construct that order by virtue of our petition. So we have more ammunition in our quiver. We don't want to use it, but we are waiting for the leadership of this district to actually respond to our emails about the integration plan, about the comprehensive equity plan, so that we can move those things forward. If they have done those things, please present them to us, because nothing in my email demonstrates any material movement in those two areas, which are the anchor of this settlement. Anything else from you, Walter? Any more questions? I think, oh wait, here's one
Well, there
more.
is another question from Anita Mack, and I'm going to get to that in 1 second. I do want to make sure that we are clear about the role of Dr. Fergus. I don't want anyone to think that we lack trust in the abilities of Dr. Fergus. Dr. Fergus has been open with the Black Parents Workshop on his work and the frustrations that he has encountered. I will also say that we agreed to the hiring of Dr. Fergus. As part of our early negotiations, the district came to us and said, would you agree to the hiring of Dr. Fergus for this role? And knowing his work and even our own education equity expert, we all said, great. He certainly has the track record and the expertise to help the district, but he himself encountered difficulties in obtaining the data that he needs to complete the requirements that the settlement imposes for his comprehensive equity plan. So I just wanted to make that clear. So the question from Anita Mack is, how can African-American allies and neighboring communities support the Black Parents Workshop? Well, I think it's encouraging people that you know who live in South Orange and Maplewood to speak up and demand that this district comply with the settlement agreement, and not just to comply with the settlement agreement, but improve the educational experience of Black children living in this community. The reason why we fashioned this settlement around K through 12 is because we understood that while there was a lot of focus on Columbia High School, the real problems exist the minute Black children enter in this public school district in elementary schools. And there's enough data to show that tracking begins that early. So if you live in another community and you have friends in South Orange and Maplewood, pick up the phone and encourage them to be vocal with the local school district about complying with this agreement. There should come the day, hopefully soon, that this will not be a matter of the Black Parents Workshop advocating for these things, that it will be the community advocating for these things, and that we can move on to doing some very progressive and proactive programming that will support children in the community. But we have to get over this hurdle first before we can get there.
Well, I will say this. We have been discussing for a while, you know, the majority of our focus, at least from my perspective, has been on the settlement. And there are people that have reached out to help in this regards and in others. And so we are in the process as an organization of discussing, significant changes to the organization. So currently, Black Parents Workshop consists of 7 trustees. It's like a public policy think tank / advocacy group, in essence. But there's more we can do. We can't do it on our own. We need the community's help as well. And so what you will probably see later this year is an announcement from us regarding certain changes. We'll probably have an organization that will be membership based not like it is now. And so those will be ways you'll be able to help in the future. But stay tuned. I don't want to give too much away at this point, but we are trying to adapt to the times. And as much as this model has worked over the years, it's going to have to take a different shape and form to meet other needs of the community, which definitely exist. And so we definitely hear your statement there, and we're going to definitely be making some changes, and you'll see them in the future. We'll get you that report, Mike. Don't worry about flagging over. Well, if there are other questions.
Yeah,
Go
if
ahead.
there are no other questions, because we don't want to hold everyone, it's Saturday, and we really do appreciate everyone coming onto this Zoom meeting. We are attempting to do what we said we would do from the very beginning, which is make certain that Black children receive an excellent education in South Orange Maplewood School District, and by benefit, all children to receive an excellent education in South Orange Maplewood School District. This has not been an easy fight. Even upon relocating to Maryland, I stayed committed to this lawsuit because I feel personally invested in it. And now with a daughter who is completing her first year of law school, who really set off these, actions as a child, and who vividly recalls the frustration of being a student in this public school district. I sincerely hope that we will get to the point after this that there will never, ever again be a reason to litigate in this district. We can't afford to do it. It's a waste of time. It's a waste of resources. We can do so much better if people would just commit themselves to better. And so I'm going to end on that note and just thank you again, everyone, for your.
Well, we got a question from Lynn's iPhone.
Okay, Lynn.
Yes, hi, good afternoon. Thank you so much for this session. I think I've learned more here, and I'm an administrator in the district than I have from the district. For example, this is the first time that I'm actually seeing what the settlement said. And I'm wondering, I know that you had mentioned that there's a monitor. Are they looking at just what the district puts on paper to say that they've done, or are they asking for evidence to support those findings?
Well, once we get the monitor in place, the monitor will have the ability to look into what the district claims it is doing. And the monitor for this settlement is probably one of the most respected jurists the state has ever had, retired Supreme Court Justice John Wallace. He's a man of impeccable legal reputation, and someone who we reached out to. We had two people on our list. We had a former New Jersey Attorney General, but unfortunately we could not work out the proper financial arrangements because he is now in private practice at a very prestigious New York City firm, and he was a bit too pricey for us. But then we reached out to Justice Wallace, who willfully said yes. And so I have every confidence in Justice Wallace. The problem is the district has not communicated with Justice Wallace as far as we know.
Thank you.
All right, folks.
I don't see any other questions.
Again, thanks for attending. Appreciate your time on this Saturday morning, afternoon, and have a great rest of your weekend.
Thanks, folks.
Thank you.